How's everyone doing today? Can you all hear me? Good? Can you all hear me? I'm pretty loud, so, all right. So I want to do a few things. Tyler, you're going to give me the high sign maybe at 10 minutes or so. I'll go till about 12:45. What was that? Or, yeah. Yeah. So let me know. I want to keep talking, so I'm just going to kind of teach this like I teach a regular class, and I want to go through just a few cases about abortion. But we got to start with the Constitution. And so if you don't have your Constitution on your phone, you should, but you can get that app anytime you want. But here's what it says in the 5th and 14th Amendments. It says, the government shall not deprive anyone of life, liberty, or property without due process of law. Now this is, we live in an amazing country because when the government does something that violates our life, liberty, and property, and you can demonstrate that, you can sue. You can go to court and convince a judge that a particular law, maybe there's a law banning flag burning. This actually happened in Texas. And maybe you think that free speech entitles you or your liberty entitles you to burn a flag. You can go to court and say, hey, Texas can't have this law. This is exactly what Johnson did. And he got the Supreme Court to strike down that law. Now that is amazing. Not every country can you do that. There is no striking down laws in North Korea because you think it violates your liberty. You can't do that everywhere. So that's what is the importance of our court system. The purpose of the Supreme Court is to interpret the Constitution, this is just one little bitty part of it, and say what the law means. And they get the final word. So they tell us what free speech means. They tell us if the right to bear arms means that we can carry handguns or means we can carry an AR-15. They get to decide. And then every state has to obey that. That's what's remarkable. Now today, we're going to talk about this deprivation of liberty. I want to figure out what this is, but I have to go to a case to do that. Now the case we're going to start with today is Griswold v. Connecticut. And this is a very famous case. Let's see if this comes up here. Turn this over. There we go. I'm a doc cam kind of guy. I don't like PowerPoints. Connecticut had a law in 1965. Maybe it was a good law, maybe it was a stupid law, but here's what the law was. Any person who uses any drug, article, or instrument for the purpose of preventing conception shall be fined or imprisoned. In other words, contraceptives were illegal. They were against the law in Connecticut. This was the law on the books. Kind of hard to enforce. There weren't a lot of people breaking into bedrooms, seeing if you used a condom, but there it is, they had a law against it. And their reason for having a law against it was perhaps they wanted to reduce fornication. Because if there are no available condoms or birth control pills, perhaps some people will have less sex, or unmarried people will have less sex. That was their reasoning. They also perhaps wanted to reduce adultery, because obviously adultery is a greater risk. If you get pregnant while having an affair and you haven't slept with your husband for a year, men are stupid, but we're not that stupid. We can add. And so people, might use contraceptives to hide affairs. So anyway, we all grew up, myself included, in a world where contraceptives are legal, but there was a time when at least one state said, we want to have the right to make it illegal. And so the court looked at this case, and Planned Parenthood had objected, because it also said in the law that anyone lower in the law, anyone who counsels someone is also responsible. So if you hand out the drug or you hand out the IUD or whatever it is that you gave somebody to prevent conception. And so the question is, does the Constitution prohibit a state restricting the use of contraceptives? Okay? And so what did the court say? Well, what the court does, the court says yes, the Constitution does prohibit that. And the argument the court gives is it goes to the Bill of Rights. Okay? And here's the Bill of Rights that are relevant. I'm just starting at the top. And what the court says is that if you read the Bill of Rights, what you will see are things like, at the very top, the freedom of speech. You can say whatever you want, short of threatening people's lives or the president or yelling bomb in a theater. You have the right to exercise your religion, and that's sort of a private activity. That's your business. The court says that no one can be courted in your house in peacetime. Your house is your property, your private property. Amendment 4 says that cops cannot search you without warrants. That's your private car, your private trunk, unless he has a warrant or he hears someone, I guess, kicking in the trunk that you've kidnapped. He can't just open your trunk. We have all these rights, and then the fifth one says you can't be a witness against yourself. So if you commit a crime, the government can never force you to testify against yourself. You can keep that private information about where you were secret if that would imply that you had committed a crime. All of these things the court says imply, and if you're writing stuff down, you can write this down, a right to privacy. There is a general right to privacy in the Constitution, is what the court says. Now, the word privacy is not in the Constitution. So some people object that they're just making this up. But they are inferring this from other rights we have in the Bill of Rights. Now this is what the court does. It reads the Constitution. The problem is the Constitution's not clear. The right to bear arms. It says right there, I've got the right to bear arms. That doesn't tell me anything about what kind of gun I can carry, where I can carry it, how onerous the regulations have to be. Maybe Massachusetts will say, yeah, you got the right to bear arms, but you got to pay $5,000 for a carry license. Well, that effectively means that poor people aren't going to have the right to bear arms in Massachusetts. And if the Massachusetts tried to do that, the court would probably strike that regulation down. So the Constitution tells us very little as to what exactly is the free exercise of religion. If your religion includes baby sacrifice, you don't get to do that, obviously. So the court says here we've got a right to privacy. Okay, and perhaps that's in the Ninth Amendment one of the other rights that it's talking about. The Ninth Amendment says just because a right's not on this list doesn't mean you don't have it. The right to vote's not up there. We certainly have the right to vote, right? So, okay. Now, so the court says they can't ban contraceptive devices. All right, fine. That's the way it'll be. Now, let me go to another case to show you. So if I put on here, if you can all see this, but I'm going to put the right to privacy, okay? And I'm going to put over here on this board the right to use contraception. And maybe you think that's good that we have a right to use contraception. I'm probably generally in favor of that. I'm not sure if I think that any 14-year-old boy should be able to walk into a store and buy contraceptive devices. That's where we are now. But that's an open question. But certainly contraceptives are generally available. Use them all you want. Okay. Now, the second thing, I want to go to Stanley first, just for a second. There's a case about privacy called Stanley versus Georgia. It's a very interesting case. I'll tell you the story. There's a guy named Robert Eli Stanley, and the cops are searching his house because they think that he might be involved in illegal gambling activity. And so they get a warrant and they go into his house. And while they're looking around for these betting slips, they discover 3 9mm rolls of film. Okay. So they get a projector that Stanley has in his den. They make some popcorn and they sit down, they watch these films. And it turns out to be hardcore pornography. I think the film was called Young Bloods. Haven't seen it yet, but anyway, there it is. And it takes them a good 45 minutes to an hour to determine that it's pornography. And so once they do, they realize that Stanley has violated a law in Georgia. The law is a law that bans the possession of obscene material. You were not allowed to possess pornography in Georgia in 1969. This is when the case is. This is 4 years after Griswold. Now, what Stanley says is, wait a minute, I've got a right to privacy to possess obscene material if I want to. This is my private home. This is where I was privately watching it when I did. You can't come in here and tell me that I can't have pornographic material. And Georgia says, yes, we can. Because Georgia says we have a lot of good reasons for wanting to ban pornography. Georgia says that pornography is bad for people. One of the things you can say about pornography is that if you think about what I hear this all secondhand, of course, from my friends who watch pornography, but here's what they tell me about porn films. Is if you watch porn films, the teaching is that you can watch as much pornography as you want. And what you'll see in porn is that the teaching is that have as much sex as you want. With strangers, with relatives, doesn't matter. Don't use contraception. Do that every day, and you will be happy. Nothing bad will ever happen to you. No one ever gets an STD in a porn film. No one's wife ever leaves them at the end of a porn film. No one gets divorced at the end of a porn film. Is that the way life really is? Certainly not. Okay, I'm sure if most people lived the lives that Randy West or Ron Jeremy live, that would cause significant relationship problems in their lives. Okay, you just can't. And so Georgia says, look, because the teaching of porn is so bad and because it's so obscene, we don't only think you can't show it in public. That might be one thing. We don't think you should even be allowed to possess it. Just like heroin. Heroin's bad for you. It's bad for your body. Georgia says that porn is bad for your mind, and so they want to ban it. Now, maybe you think that's a good idea. Maybe not. I know when I was 13 years old, porn was very hard to come by for me. I was looking for porn, and I couldn't order it through the mail because you have to have a checkbook or a credit card, right? I couldn't walk in to the adult bookstore because you got to be 21. It wasn't on TV as far as porn access on cable. I didn't know that sleazy 7th grade student who got the VHS tape from his dad, right? We all knew that guy in middle school, the guy who had access to the porn. I didn't know that guy. I didn't watch porn until I was like 17 or 18. Sad. Today, how hard would it be for a 13-year-old to see pornography? Not hard at all. In fact, 95% of 13-year-old boys especially have seen porn. Okay? Now, I like liberty too, but you might ask yourself, I'm just putting this out there as a suggestion, is it possible that there's too much liberty in this respect? Perhaps not. Perhaps it's too hard to regulate and we can't do anything anymore. But I want to give you two scenarios here. Too little liberty and too much liberty. I want to be someplace in the middle. Anyway, Stanley won this case. And he won this case because of the right to privacy. And what he says was one of the great lines of the case is that if the First Amendment means anything, and not only the First Amendment, but they're also referring to this notion of liberty. It means that the state has no business telling a man sitting alone, very alone, in his own house, what books he may read or what films he may watch. The state has no business interfering with that man's private decision about whether or not to watch porn. Now, Stanley v. Georgia is a key case because and what Stanley v. Georgia basically says is that although we're going to let states regulate, we're not going to let states regulate things like morals or things that have to do with people's minds. We're not going to do it. This is a huge privacy case because Stanley is the big privacy case before Roe v. Wade. There is no Roe v. Wade without Griswold or without Stanley. And so we get to Roe v. Wade, which we all have heard of, but few people have read. Let's go to Roe. Let's go to the law in Roe v. Wade. Now, Texas had a law. It wasn't an unusual law. There were many states who had laws like this. And the law was that no one, I'll just summarize it for you. Well, actually, it's important to read. If any person shall administer to a pregnant woman with her consent any drug or medicine, and thereby procure an abortion, he shall be confined in the penitentiary for 2 to 5 years. This is a punishment specifically for the doctor. Generally, abortion laws applied to doctors. Women were not being sent to prison for getting abortions. But what would happen, doctors would lose their medical licenses and go to prison for committing abortions. And so if you were a woman, your challenge to get the abortion was to find a doctor who would do it. And you might be able to find one, you might not, because not a lot of doctors are going to risk their medical careers to do something illegal that costs them their license. That's their livelihood. Now, notice, by the way, Article 1196. People forget about this. There was an exception for saving the life of the mother. That's always been an exception in abortion laws. So if you can show that your life's going to be in danger, even in Texas in 1970, you could get an abortion. Okay, but that's less than 1% of cases. 99% of abortions are not done to save the life of the mother. Okay? Now, we might ask ourselves, why is it that women get abortions? Because that's an important question. What is it? Why is it that women get abortions? Let me just bring up I have a short list. Hey, I got louder all of a sudden. Okay, well, here it is. Well, it's this. Help me out. Why do people get abortions? Feel free to call out. Anybody? Okay, age. Good. What else? Yeah, economic reasons. Absolutely. That's the most common, in fact. What else? Help me out. Yeah, but I'll put rape over here in a special category. There are 3 really horrific reasons, and rape is one of them. Let me write the other 2 down. Incest, which is family sex, and life of the mother. That's less than 1% of all abortions, by the way. Okay? But that's, certainly these are pretty controversial. The other reasons, we got economics, we got shame, we got going to college perhaps or getting an education, we got career reasons. I'll put dollar signs up here again just to emphasize financial reasons. Maybe she wants to be on the volleyball team next year, and she's going to be all-state varsity. So maybe she wants to do it for that reason. Maybe she doesn't like kids, doesn't want kids. Or maybe she has no reason at all. Okay, she'll have some reason, but the state will say shouldn't have to give a reason. But whole number of reasons why women get abortions. Some of these reasons are obviously better than others, right? I mean, certainly being raped, even if you're pro-life, you have to pause a little bit before you're gonna make that woman bring that pregnancy to term. You might have to think about it, as opposed to she tells you, well, I'm a athlete and I want to keep playing. That's not going to persuade someone who's pro-life, let's say. But all of these reasons why women get abortions, age, economics, shame, and there's more. There's certainly more reasons up there. I'm just putting a few of those up there. But Texas wants to say that they can't do that. Now, let me put a chart about how this used to be in 1970. This is the way, this is a useful chart. These are your 3 options about how your regime is going to handle something like abortion. Okay? We could do any of these 3 things. You could say that we're going to make abortion illegal everywhere. Okay? So maybe you're against abortion. Maybe you think abortion is the killing of a person. And maybe you think that no state should allow it. You can have an exception for the life of the mother. You can have whatever exceptions you want. But you can have an exception for the life of the mother. And that says, so the argument there would be, there's certain pro-lifers who would say this, many of them. The fetus is a person, terminating him or her is a homicide, except when saving the life of the mother. That could be a view we could take. And so there would be a federal law banning abortion everywhere. Okay? We could do that. The opposite view of that is the pro-choice view. Okay? This is the more liberal view. Woman's right to terminate her pregnancy is fundamental and should be legally permissible for any reason. Okay? The fetus is not something that has any rights that trump the woman's sovereign choice to decide to terminate a pregnancy. Now, you could still say, well, at some point in the pregnancy, maybe after 6 months, 7 months, 8 months, she has to decide. But at least in the first trimester, we'll say the first 3 months, first 3 or 4 months, it's up to her. That's the pro-choice position on the left. Now, there is a middle position that people don't think about. Let the states decide. The state can allow or prohibit abortion as they see fit. So it'll be totally a state issue. Okay? And so in Texas, they might say it's illegal, but in New Mexico, they might say it's legal. And this was the situation in 1970, before Roe, or Norma McCovey was her name, before she brought her case. State by state, each state would decide. She could have driven to Louisiana and gotten an abortion. But she didn't think she should have to do that. She thought that was an undue burden on her rights. And perhaps there are poor women who could not afford to take the long drive and miss work and so on. I understand. There were, in fact, in 1970, people forget, pro-choice was winning the argument. 29 of the 50 states permitted abortion. We often think back to the 70s, like for Roe v. Wade, there must not have been abortions anywhere. Well, no, that wasn't the case. True, it was more accessible for women who probably had more money because they could fly wherever they wanted to get the abortion. I understand that. But they were winning, and I'm sure by today we'd probably have 5 or 10 states left that would prohibit abortion had we not had Roe v. Wade. But we did. And what the court says is, no, abortion has to be legal everywhere. But I want to talk about the argument the court makes. And the court makes the argument that you've seen before. All right. This is at the bottom here. It talks about the liberty. The Constitution nowhere mentions anything about marriage and family. There's no passages about sex or pregnancy or marriage anywhere in the Constitution. But it does talk about liberty. It does talk about the liberty by the Due Process Clause. That was that quote, right, we just had before, liberty right there. It talks about liberty, and the court says that necessarily includes the right of a woman to decide whether or not to terminate her pregnancy. You see how important the court is? They inferred that the same way they inferred in the contraception case and in the pornography case. Now, you may or may not agree with their inference, because there is a different issue in this case than in the contraception case or the porn case. The problem with this case is I have competing rights. And this is where Supreme Court justices really earn their money. I think they're paid about $250,000 a year. Because it's not just the right to liberty I have to concern myself with. That is a definite right in the Constitution, and we have to consider that. Absolutely. The problem in abortion is the competing interest would be the right to life of the fetus. Now, we're going to have to figure out whether or not the fetus has any claim to life as listed in the 5th and 14th Amendments. We didn't have this problem in the porn case. There's no right of the porn film or right of the porn actress or the porn distributor. And, the contraceptives obviously aren't alive. The fetus might be. We have to consider that. In order to consider that question, we're going to have to figure out, now I need an eraser. Here it is. We're going to have to figure out, I want you to think about this, what is a person? This is the fundamental question of Roe v. Wade, which I never ever hear talked about on TV, as much as I'd like. I want to know what a person is. I want to know, because, see, we have a timeline here, right? We have conception, put that right here, and we have birth. And we have a lot of stuff in between. We have I guess before conception, we have sex. Before sex, I guess we have dinner and drinks or something. And then we have a heartbeat. We have brain activity. We have arms and legs. I'm going to go ahead and just put 24 weeks because that becomes, let's call 24 weeks. We're going to call that viability. And that's going to be the term we use for when the fetus could exist outside the mother given modern technology. Obviously, viability is going to change. Right now, if you make it to 6 months, you've got a pretty decent chance. Not every time, but we can do that, more or less. 100 years ago, no chance. No chance for you. But today, so this changes, and then we'll have 9 months and 8 months and so on. Okay. Now, let me just take a poll here. You could stand up if you want. You don't have to, but I'm just going to see where the room is. How many people think that after you're born, okay, after you're born, you're in the hospital, you've just been hit, first thing that happens is you get hit, and you're crying, you got a crying baby. Stand up if you think that crying baby is a person, and it should be against the law to terminate that person. Stand up if that's your view. The baby that's 1 minute old is a person, and it should be against the law for the woman to kill that person if she wants to. She says, I don't want to be a mother anymore, and she wants to kill the infant. You're all standing up, I'm guessing. Okay. Now stay standing. Let's go back to 8 months. Now the woman is 8 months pregnant. Stay standing if it should be against the law for her just for convenience. She just decides she doesn't want kids. That's her reason we're going to give. Doesn't want kids. Okay? Let's go back to 6 months. She's 6 months pregnant, and she wants to terminate her pregnancy. Stay standing if she should not be allowed to terminate her pregnancy at 6 months. She should not be allowed. It should be against the law. You're all still standing. So that tells me you all think it's a person at 6 months. Okay, fine. Let's go back to 3 months. It's 3 months. She's 12 weeks pregnant, and she wants to get an abortion. Stay standing if it should be against the law for her to do so. Okay, I lost some people. Okay. It's 3 weeks. She's just found out she's pregnant. It's 3 weeks. She wants to get an abortion. Stay standing if it should be against the law. That's a person. Okay, have a seat, everybody. Good. All I did that for was to demonstrate that we have different ideas of what a person is in this room. We have disagreement. I wish I had answers for you. This is a hard question. Usually, if you're writing stuff down, I would say write this down because I'm teaching, but this is a philosophic question. This is a question of philosophy. This is not a medical question. I can't stress that enough. Doctors can give me no insight into whether or not this thing here, at whatever age, is a person. All the doctor can tell me are physical things about it. Can tell me about arms and legs and spleen and liver and cells and development. Doctors are brilliant biologists. They can tell me all sorts of things I want to know. But they can't tell me when is it a person and when does it get all the rights that we're going to give people in this country. That's what's hard about this issue. If it were just pornography, okay. But this could be, I should say, could be a person. It might not be. It might just be tissue. You ask Barbara Boxer when it's a person, she's going to say when it's on the way home from the hospital and part of the family. Now that's an extreme view. But there are some pro-choice people on the far, far left that think women should be allowed to get late-term abortions, even if their lives aren't in danger. Now, many pro-choicers, though, most of them would say, it's always tough to corner them on when exactly they think it becomes a person. See, here's the challenge for the progressive. I'll pick on progressives for a second, then I'll try to pick on the conservatives a little bit. The challenge for the progressive is if you said at 6 months it's a person, but at 3 months it's not. Let's say that was your view. I'm going to ask you, what happened between month 3 and month 6? Surely it got bigger. And surely it got more developed, and muscles and bone structure. All sorts of things happened. Where was the moment where it achieved personhood? Because that's an important moment, right? That's the difference between life or death for that fetus. Now the challenge for the conservative is going to be if you say it starts at conception, which a lot of conservatives will say. The pro-life person will say that. It doesn't resemble anything like what we call persons at the conception point. It's barely a collection of cells at that point. So I don't know. We all agree it's a person after birth. Some of us say this is the fundamental question of Roe v. Wade. Now the court decided to weigh in. Of course, they're not philosopher kings, but they were very sure, at least 7-2, they were very sure that the right necessarily included the right of a woman to terminate her pregnancy. When you ask the court about this personhood question, here's what they do. Some argue that the fetus is a person within the language and meaning of the 14th Amendment. But the court asserts that that obviously doesn't include the unborn. And if you read the Constitution, you could say, every time the Constitution uses person, it's talking about counting people for the purpose of representation. It's talking about people who have free speech and the right to bear arms. Obviously, a fetus can't engage in free speech and doesn't have a home you can break into. So person only means after birth in the Constitution. That's what the court said. Doesn't mean the court's right. They might be. They might not be. Fundamental question. But that's what they do. So they don't even have to deal with the question of whether it's a person. The court also talks about all of the political or all of the social problems that would result for women if you didn't allow them to get abortions. All right. It could be a distressful life and future, psychological harm, okay. Mental and physical health may be taxed by child care. There is a distress for all concerned associated with the unwanted child. And those are all reasonable points. Those are all true. There's certainly cases we can think of where that's true. This is less true, of course, today than it was in 1970. I've been reading about safe haven laws. And when you have discussions of abortion with your friends, ask them about safe haven. Discuss safe haven laws. This was not the case in 1970. You had a child in 1970, you had to keep it. You could try to get it up for adoption, but that's a long and onerous process, and not everyone's going to take a baby from every person who has an unwanted child, especially maybe. But look at this law here. Every state has this today. In Texas, you can leave your baby up to 60 days old with an employee on duty at any hospital, emergency medical services provider, or child welfare agency. So anyone who has a child, you get 2 months in Texas. Most states have like 3 days. But Texas gives you even more time because Texas doesn't want people killing their infants because they are feeling taxed by psychological harm and distress in their future. There was a college girl this weekend that killed her infant, I saw on Facebook. Totally unnecessary. Now, I guess if you're willing to kill your infant, you probably don't have the wherewithal to consider driving down to the hospital. So what the abortion conversation is today now, it's not so much that you're requiring an entire lifetime altered. What you're now requiring is the altering of a certain amount of months. Could be 4 or 5 months, 6 months, whatever it is. There still may be some shame involved, but, you still might have to have the financial resources to make it through those months. But we're not necessarily talking about a lifetime anymore. Now, these are new. These come around, I think, in 2008, 2009 is when you really get the push for safe haven laws. I don't hear pro-lifers using this a lot as part of the argument anymore, because they want to go all or nothing. They want to talk about the life is sacred, and that's fine, and that may be the case. But this, if you're a pro-lifer out there, this would be something to consider. And if you're a pro-choice person, you might ask yourself, well, is the need for abortion rights as serious as it once was, I guess, if we have these safe haven laws? Maybe you say yes. Absolutely, yes, absolutely. Maybe you say no. Texas Family Code 262. I find that interesting. Okay, let me move off abortion for a second and tell you where the conversation has gone to Planned Parenthood versus Casey. So in 1992, abortion's legal. States can't just ban abortion. Okay. So what do states try to do instead? Well, they try to regulate abortion. They try to make a number of rules that exist before you get the abortion. And so here is what they did in Pennsylvania. And I'll just tell you the things first of all. There's so many papers here. First thing they say is if you want to get an abortion, you're going to have to get informed consent from the doctor, which means he has to explain to you all of the possible side effects of the abortion. Abortions are relatively safe, but sometimes there are side effects. Tell you about the procedure, has to tell you about the gestational age of the fetus. He has to give you information about state adoption options, has to inform you if you didn't know that the father is liable for child support. Some women, 16, may have never been pregnant before. They don't know child custody or child support laws. And maybe they're having this abortion for economic reasons, and maybe once you tell them that it's possible, they may change their mind. So that what Pennsylvania is aiming to do is two things. Certainly, they will say they have the self and welfare of women in mind, but they'll also admit, I think, at least maybe in private, they want to reduce the number of abortions. So you have to get this informed consent, and you have to wait 24 hours before you can get the abortion. So you got to think about it. You can give you all this information, and you got to go home and think about it. Now, Planned Parenthood didn't like this at all. They thought a woman should be able to go in, no questions asked, and get the abortion right then and there. Because they thought that there would be some doctors who would use this to manipulate women into keeping the baby, to try to guilt them or shame them or whatnot. Okay, so Planned Parenthood versus Casey was the governor, they said, we don't like that restriction, get rid of it. Okay, there was another regulation, parental notification. If you're under 18, you got to get a parent to consent to the abortion. Okay, well, sounds reasonable enough. There is an option to go to a judge if you have a really good reason. Maybe it was incest. Maybe you have alcoholic, abusive parents. Maybe your parents are dead. Maybe they're in prison. There are ways, but for the average Frisco 16-year-old girl, she's going to have to get one of her parents to sign off. Now, some parents are going to say no. Some parents won't give their consent. Some parents will. Planned Parenthood didn't like that at all. They think a 16-year-old girl should be able to go on her own and get an abortion without notifying anybody, including her parents. Okay, maybe you think that's a good idea. The other requirement was spousal notification. So we got informed consent. We got the 24-hour waiting period. We've got parental notification, and we've got our parental consent, and spousal notification. You have to tell your husband, not your boyfriend, he has no rights in this area. You got to tell your husband you're pregnant before you get the abortion. I've always wondered about men's rights in the abortion debate, of course. And men, sorry to say, we don't have any rights. She wants to get the abortion, she can get the abortion. She wants to keep it, you're keeping it. You don't have any legal say in the matter at all. Now, you had some say, for however hours or minutes that was, back at the conception moment. You had some say. You were necessary, in fact. There would be no baby without you. But when it comes to whether or not you keep it or it gets aborted, you don't get any say. Now, maybe you think that's right or not. I don't know. That's a tough question, though, isn't it? I mean, I can see why, because look, let's say the guy wants to have the abortion. She wants her to get the abortion, and she wants to keep it. And she does keep it. Guess what? He has to pay child support. Now, maybe you say, yeah, damn right. But he has no say in this. And that's, maybe it's because she's the one that's pregnant, right? That's the obvious answer. Is that really decisive? I guess if men were pregnant, it'd be up to us. If you have to pay child support, your life is affected by that child. Now, maybe not to the same extent hers is. I get that. But that's an interesting question that we do that. But anyway, spousal notification. So what the court said is all of these regulations are reasonable except spousal notification they struck down. They said that it's certainly reasonable for someone to have to get information about the procedure and have to wait a reasonable amount of time, 24 hours, before deciding. They said that's reasonable. You have the state's legitimate interest that the woman is sure she knows what she's doing and she's informed about what she's doing. That's reasonable, the court says. Now, if they made it you have to wait 2 weeks or you have to wait a month, well then, right, that would be unreasonable, but this is not. And the standard, by the way, you should note, is undue burden. That's the term that is used today to describe when the state makes a regulation that's an undue burden on the woman trying to get the abortion. You have to run a 5-minute mile before you get an abortion. That would be a regulation that most people could not do. So you're effectively saying if you can't run very fast, you can't get an abortion. That's just to make abortion illegal. Oh, but it's not against the law. Yeah, but who can run a 5-minute mile? Very few people. You got to pay a $10,000 tax to get an abortion. You have to get, an abortion. That's onerous. But the court says no, this is fine. And certainly it's reasonable to require minors to get parent permission. They have to do that for any other type of procedure. Why would abortion be any different? There is a judicial bypass, but the court says, look, parents generally have the best interests of their children at heart. The court's going to say, you're a minor, unless you're emancipated, you're going to have to get your parents' permission. All right, fine. But they do strike down spousal notification because their concern there is spousal abuse. Oftentimes the reason that a wife doesn't want to tell her husband she's pregnant is there are significant problems in the marriage. Could be spousal abuse. Could be he's an alcoholic. And explaining to an alcoholic husband that you're not going to carry his baby, he may get upset about that. And so they're concerned about violence against women. That seems reasonable. So that's gone. No, husbands have no right to even know that their wife was pregnant. Some of you might like that, some of you might not. Now, so this is where the battle is fought today. So what pro-life states want to do, or states that have a large amount of conservatives, they can't make abortion against the law. Roe v. Wade has been settled. Maybe someday if there's a new court, who knows, but for the time being, I don't see Roe v. Wade going away anytime soon. What conservatives would like is for them to go back to This model, if you overturned Roe v. Wade tomorrow, you would go back to the middle option. The state legislatures would decide. Now, I'm guessing shortly thereafter in Texas, abortion would be against the law unless it was to save the life of the mother. Maybe there would be a rape exception. Maybe an incest exception. But for the most part, a lot of the really conservative states would be pro-life again. Nothing would change in California. They'd have the same abortion laws they have today. Would be up to the states. People think you overturn Roe v. Wade and suddenly abortion's illegal everywhere. Well, that's not the case. You have to have a federal law. You'd have to have the Congress and the Senate and then the President sign a law saying that fetuses are persons, or pass a constitutional amendment that says that. That's how you would get it illegal everywhere. I don't see that happening anytime soon. Okay. Just one more point. I don't know how I'm on time, Tyler. Oh, okay. Well, I'm going to get done really good. Let's see. I think that was the argument I wanted to make. There was a recent case I'll just tell you about. Whole Woman's Health versus Hellerstedt. This is 2016. This just happened. Texas passed a law, HB 2, a couple years ago. And they wanted to require all abortion clinics, the doctor had to have admitting privileges at a hospital within 30 miles, which is not necessarily easy to obtain for abortion doctors. Some hospitals don't want you to be on their staff if you're doing abortions. And the other requirement is that every abortion clinic had to have the facilities for an ambulatory surgical center. And what that meant is they would have to have building codes and equipment for a regular surgery center. That could cost, in some cases, millions of dollars. Okay? So what Texas was trying to do now Texas will tell you, well, we're doing this for the health and safety of women, because having a doctor with admitting privileges will be beneficial in some cases, although it was hard for them to say exactly when, because most of them do have these transfer agreements, but okay. And there are complications in abortion. I think 5-6% require an ER visit. I hear different stats on this, but up to 5%, let's say. And they said, wouldn't it be great if the clinic itself had all the equipment and facilities to handle that emergency rather than, say, going to the hospital? Now, these are rare. These don't happen very often. And so they tried to convince the court to let them have these regulations. Now, what happened after they had these regulations pass, about 80% of the abortion clinics in Texas had to close. If you're a pro-life supporter, that's brilliant legislation. Wow, we just reduced abortions by 80%. Because these places could not stay open because they didn't meet the requirements of the law. They didn't have the money to retrofit their places. They didn't have doctors who were on staff. And so the argument was, if you're a woman, so now you had only like 7 abortion clinics left. And if you were a woman that lived out on the 200 miles away from an abortion clinic, was this an undue burden for you to have to travel all that distance to go make the appointment? Then you had to wait 24 hours or whatever the law says, right? So this wasn't the case, right? So the claim on the pro-choice side is, well, first of all, you've shut down 80% of the abortion clinics. Not only will it be hard for women to get to these clinics who are living far away, these existing clinics are going to be over capacity. There was something like 70 or 80,000 abortions in Texas last year. With the 7 remaining clinics, they were only going to be able to do like 15,000 abortions. That's doing abortions from open to close every day. Well, so you have a capacity problem. Now, but look, you can't blame Texas for trying, right? I mean, Texas is a pro-life state. They got legislators who would rather this just be illegal entirely. So what states will do, and I think if the legislators were honest, and I brought one up here, they would admit, yes, what we were trying to do is reduce the number of abortions because we think abortion's bad. That's what the honest legislator should say. it was hard for them to convince the judges this had anything to do with health and safety. And they didn't. The judges struck it down 5-3. Now, Alito and Roberts and Thomas thought that, look, if the state of Texas wants to have these regulations, they can, so long as they haven't made abortion illegal. If you need to build a multi-million-dollar facility, then do it. And you might have to, you might have a capacity problem for a short time, but eventually, there are rich Democrats in Texas. They can build these facilities. They didn't say this. I'm saying this, but they could build these up. It might take some time, but the majority of the court was not persuaded. But that's where the issue stands. Pro-choice people do not like really hardly any regulations on abortion, and the ones we do have, they will complain about. And so that's the battle. All right. Well, that's it, I think. Yeah. Thank you for your time.